Hello, my name is Nagasai Purovich and today I am going to talk about how prospection of patents in India. The prospection of patents is a process where applications or the representatives interact with the patent office to grant their patent application. Since this process is time intensive and often requires negotiation with the patent partners, it mostly becomes imperative to understand the basic mechanism of patent prospection process for the smooth journey process. Smooth journey. The patent process in India is that every patent has their own. There are fundamental patent prosecutions for the Indian application seeking for the patent protection in India, where there are the patent prosecution system in India, pre-grant prosecution stages and post-grant prosecution stages. Now, under pre-grant now we have to know how we are going to use the patent prosecution system in India, how it is done. Every patent prosecution begins with the filing of the patent application before the Indian Patent Office. Post filing, the office verifies the documents to confirm the completeness of all requirements. Therefore, the application is sent for the technical examination and check whether the invention meets the three basic requirements, which is novelty, inevitability, and industrial applicability. During this stage, the examiner have expertise in this topic technical domain judicious examines the application. In the case of examiner has many objections in the term of patentability and the formal requirements in the application, he or she incorporates these objections in an examination report and send it to the applicants or their representatives for submitting their response within the stipulated time. Given below is the timeline of the patent prosecution in India, where we can see the drafting the process and the placement, drafting and filing of the patent application. It may take up to 18 months. Then is the publication of patent application. It may take up to 48 months. Then is the filing and request for the examination. It may take so much time that it may even go up to 2 years. Then is insuation of the examination report, where it may happen within 6 months or up to 3 months, and it can be even extended up to 3 months. Then filing the response to the examination report. Then hearing with the controller, and then it will take up to 15 days. Then next is the filing of the hearing of the submission. Then the patent is granted or rejected. And this whole process may take up to 8 months or 3 to 6 years. Now that we have idea about overall prosecution process, now let us discuss the phases of patent prosecution. Patent prosecutions. The patent prosecutions are divided into two types. The first phase is the pre-grant prosecution that involves the examination the process conducted by the patent officer. This includes the issuance of examination report by the officer as well as drafting and filing a response to the report within the prescribed time limit. If the examination is not satisfied with the argument submitted in the response, then he or she issues a separate notice. Pre-grant oppositions, after which the application proceeds for the grant or rejection, are also included in this phase. The second phase is the post-grant prosecutions that takes place after grant of a patent. This may include post-grant oppositions and post-grant amendments. In the pre-grant prosecution stages, there is the filling and publication. A patent application must be filled with the Indian Patent Office to get patent. This application can be provisional or non-provisional. Complete application. In India, the Patent Office functions from 4 jurisdictions, which is Kolkata, Delhi, Chennai and Mumbai. The application must be filed at appropriate jurisdiction, which is decided based on the following requirements: applicant's place, residence, domicile place, or any joint addresses, and the place from where their invention originated from, or in case of foreign applicant, the address for the given service in India given by the applicant. Once the non-provisional application is carefully drafted and filed with the patent office with all the necessary documents along with the prescribed fees, the office assigns a unique patent application number, the filing date or the prior date to the application for the reference and the record purposes. Such first filed applications are known as the priority applications, and in the date of filing is referred to as priority date, usually after expiry of 18 months. From the filing date or to the priority date, the patent application gets published in the official Gazette of India and comes into the public domain. To fast track the overall process, B are requested for the publication can be filed at any time filing the application with the patent officer. The application gets published within 1 month from the date of filing such a result. The applicant gets all the patent rights from the date of publication of the patent application. However, these rights can be only claimed if the application is ultimately granted in the patent and only after final grant. Search and examination. This is the most important step of the prosecution process that decides the fate of patent application. During this stage, the patent officer reviews all the formal documents and the patent examiner conducts the worldwide view and check worldwide patentability search that given features of the invention is check for the closest prior art to the relevant application in the question. Based on this prior art, the examiner decides whether the invention which for the patent application is filed novel, interventional and capable of industrial applications. Further, the examiner also looks for those inventions that are strictly excluded from the patentability and are known as non-patentable inventions. Ordinarily, the examination stages may take up to 3 to 6 years, but for some applications this process may take up to only 8 years. After the process of India, the International Searching Authority of the International Preliminary Examination Authority in corresponding to the PCT application. Application is start in a small entity. The application is a female or a case of joint application where all the applications are natural at least one of the applicant is female. Next, when the applicant is an eligible educational institute which owned or controlled by the government. The issue of the examination report. If the examination report finds that the lacks novelty, then he or she enlists such objections in the examination report, send it to the applicants and their representatives. The applicant must overcome every objection cited in the report within the prescribed time to further the process. Response to the application examination report. It is more important. We have to decide to modify or amend the specifications claims. Such modifications, however, should remain within the scope of original applications. After receiving the response, the examiner reviews all the arguments and the amendments that the applicant has submitted and proceeds to the next step. Subsequent examination reports are hearing before the examiner. If the examiner is satisfied with all arguments and the amendments, he or she proceeds to the issuing stage, a patent certificate to the applicant. But if the examiner is unsatisfied with the applicant response to the examiner, he or she can issue a second examination report for the hearing notice to resolve the matter. The applicant gets another opportunity to submit his or her response for the second examination report or appear for the hearing before the examiner and file hearing submission within the prescribed time. Pre-grant opposition. The search examination mainly takes the place between the examiner and the applicant. However, in this jurisdiction, such as India, there are third party called as the opponent and can oppose the grant of the patent based on the central grounds. This can also done immediately after publication of the application but before the patent grant. Under section 25 the Patent Act, the pre-grant opposition can be filed by any person without paying the official filing fee. The proceed of the pre-grant opposition involves filing of the statement, reply and support advice by the both parties. These parties usually request hearing before the examiner he or she passes any order of the decision from the particular application. Decision of the examiner. The examiner once again reviews the examiner final decision whether the process is granted or refused. In this case, the patent application, then the hearing notice is issued to the both of the applicants and the opponent before passing the final order. Sometimes the applicant decided to opt for the international protection via convention or patent contemporary treaty, in which the PCT Act. In the PCT Act, the application within 12 months after filing the first application or the prior applications, independently, as the each country has different laws. The applicants can also apply from their foreign policies. Next is the post-grant prosecution process. In the post-grant process, under Section 25 of the Patents Act, a post-grant opposition can be filed after the grant of the patent, but within 1 year from the date of application. Based on this, the ground describes that under the said section, unlike grant opposition, post-grant opposition can be filed by person interested. Only he or she must pay the prescribed official fee based on the entity process. Another difference between two oppositions lies in the formality of an opposition board at the patent office to examine the documents filed by the opponent and the patentee, and this subsequently examiner issues a hearing notice to both the parties and decides whether the patent can be maintained, revoked or amended. The post-grant amendments under Section 56 and the 59 the Patent Amendment Act provides the provision of the pre-grant and the post-grant amendments. So, Section 59 states that the proposed amendments must meet the following requirements. The amendments should be by way of correction, disclaimer or examination. The amendments must be made for the incorporation of a fact. The amendments to specifications or claims should not go beyond the subject matter of original filed, specified or claimed respectively. Such amendments may include the following details: amendments in address, details or any address for the service. Amendments in incomplete specification includes the prior date of the claim. Additionally, Section 74 empowers the examiner to correct any critical error which may occur by this process. In the conclusion, we can say that there is a lot of there is an important, thus we have to have a strong legality by our side to assist you and represent your application at each step during this process, and even the slightest negligence may result in the rejection and amendment of the application. In our India, the patent filing and prosecution process enables you to secure the inventions by leveraging a strong patent draft prepared by skilled patent attorneys. Then the Indian patent agents and the patent attorneys with the technical backgrounds in domains such as electronics and life, who can help you make the right decisions. And thank you.